The parents of a Michigan high school shooter, Ethan Crumbley, have been sentenced to 10 to 15 years in prison. Both been convicted of involuntary manslaughter, becoming the first parents in the U.S. to be held criminally responsible for their child's mass shooting. The then 15-year-old killing 4 students, Tate Meyer, Hannah St. Juliana, Madison Baldwin, and Justin Schilling in the 2021 shooting. The parents of the victims delivering emotional impact statements during the sentencing. Watch.
This tragedy has taken an incredible toll on our family.
I request that the maximum sentence be enforced, as it will never come close to the life sentence I was given.
We're coming up on 2.5 years now, and I can assure you that the wounds are still as fresh as they were on that tragic day.
I am forever denied the chance to hold her or her future children in my arms.
Katie Cherkasky is a constitutional law attorney and former federal prosecutor. She joins me now. Katie, your reaction to the sentences?
Well, those were very significant sentences. Obviously, this is an unprecedented finding of convictions for manslaughter for the parents of a school shooter. But clearly, the judge communicated that she felt that there was a lot of aggravating factors, including the nature of the offenses and perhaps the lack of remorse of the parents that led to that very high sentence.
Well, let's listen to the parents. Here's what the Crumbley parents had to say yesterday.
This is done by filing a claim of appeal by right, or when you are not entitled to file a claim of appeal by right, an application for leave to appeal.
Okay, obviously we didn't hear from the parents there, but in general they said they were apologetic. But they also had an implication that this could happen to any parent out there. And even though this conviction and sentence came down from a Michigan court, to their point, what precedent could this set in the other 49 states?
Well, it's a very interesting charging scheme that was used here. Essentially, the prosecutor said that the parents' recklessness in ignoring their son's signs of mental issues and ignoring some other issues with the school that they were aware of on the very day of the shooting was reckless enough to be criminal. And so in terms of liability for parents in other circumstances, there's really no telling what the extent of that is. If parents do have some information that their child struggles with something, if they do give their children access to maybe even a car or alcohol, or in this case a gun, then could they be held criminally responsible? Historically, we haven't seen that, but with the precedent set here, there is that possibility for other prosecutions to take place.
Yeah, it really is a where do you draw the line question. In your experience, knowing how the system works, knowing how federal prosecutors and prosecutors in general work, do you expect to see more prosecutions of parents, not just for a horrific school shooting, but other acts that a kid could take for which the parent could not just be held civilly responsible, which they are in many instances now, but this criminal liability attaching?
Well, I think that it's very possible, but in this case, we have to remember that there's very specific evidence of the foreseeability that the prosecution kind of displayed that the parents had to their son's ultimate shooting. So they were aware that he had mental health issues. They were aware that they had given him access to a firearm. And then, of course, on the day of the shooting, they were aware that he had made some very specific drawings that seemed very threatening. And so in that case, when you have those very close ties to the ultimate act, the foreseeability is easy to see, or at least that's what the jury found here. So I think you'd have to have more than just issues hypothetically with a child that then led to a criminal act. But again, the waters haven't been tested yet. So certainly I think that there could be some creative prosecutors out there that try to hold parents responsible for any criminal acts of their minor children.
I'm glad you mentioned the word foreseeability, because that leads me to think there's going to be a state legislature, one or two, or maybe a bunch out there, that create a standard of care. In about 10 seconds, could you see these legislators creating a standard of care, codifying it in law?
Well, they could do that, but they don't necessarily have to, because we already have the recklessness statutes on the books, which is what was used in this case. It wasn't a new statute, but certainly if they want to be more specific about parents' liability for foreseeable acts of their minor children, then that is very possible.
This case is a horrific case. We pray for those families that gave those statements. But from a legal perspective, this just opened up a new world of law, I think, and we all have to be on the lookout for it. It's going to be interesting to see how it plays out. Katie Cherkasky, is always a pleasure. Thank you.
Thank you.
Carly, over to you.